Your Honor. May it please the Court, my name is Mike Cohen. I represent Orrin Green below. It is my honor and distinct privilege to appear before you to argue this significant question. I know the Justices asked about the 2-year rule.
Well, before that, is there a basis in this appellate record to conclude that this trial judge did not advise this defendant?
Yes, Justice Wells.
Is there a transcript?
There is no transcript, and I readily admit it.
The 4th District's wrong about that.
It's wrong, and what I said in my brief, Your Honor, Justice Wells, is that the error was harmless, because if you look at the record, there existed no transcript because of the passage of time. There is an administrative rule in Broward County when a case is more than 10 years old, there are no transcripts available. But if you look at the waiver of rights form in this case, and I can tell you the waiver of rights forms in Broward County, in present-day Broward County, always have an admonition as to deportation warnings. This waiver of rights form did not. And Mr. Green had sworn in his petition.
But in order for us to resolve this case, we would have to hold that it's not what went on between the judge and the defendant orally, it's what's in the rights.
No, sir. There's a sworn petition from Mr. Green that he did not get the admonition, first of all, in connection with the waiver of rights form as well, which has no deportation warning.
My second question is,
yes, sir.
Is this motion under 3.850?
It is, sir.
Okay. Now, what specific provision under 3.850 do you say avoids the 2-year limitation of 3.850?
And I think that's what's so significant about the difference of these type of cases, to address some of Justice Lewis's concerns, and the normal 3.850 case where you have 2 years from the time of a judgment or conviction to bring it. And the issue all revolves around prejudice. In this case, what happened was there was an immediate relative petition filed by Mr. Green's wife to allow him to adjust his status to a permanent resident. Because he had an uncounseled criminal conviction, he did not learn of the consequences of deportability until the waiver was denied.
I'm more concerned about the procedure. And the procedure under our 3.850 rule has a very bright line 2-year rule. There are 3 exceptions to it. Which exception do you claim? Was this newly discovered evidence?
No, sir.
Or was this a constitutional?
No, sir. It's based on Pert versus State. In Pert versus State, this court ruled that the defendant had 2 years from the time that he learned of the deportation consequences to file this kind of petition.
You would agree that Pert was a situation in which we were dealing with an error writ coram nobis.
As to non-custodial defendants, and it really didn't address this issue, but I think what the court did recognize, Justice Wells, is that this is a different forum when it comes to people with immigration problems. For instance, in this case, the defendant was rendered inadmissible because his status was in question. In other words, he was convicted of assault and battery, what we say were a basis for the right to set aside the plea. Until he filed a waiver, and until that waiver was denied many years later, he was not prejudiced by the denial of that waiver. So to have a straight 2-year...
Of course, the question is whether he's prejudiced even now.
Oh, very much so, because what happened...
That's certainly an issue here.
Very much so, and I'll explain why, Judge, if you look at my brief. When the waiver was denied on the basis of this conviction, he no longer had any right to remain and stay in the United States. He was an overstay. He had overstayed his visa, so he became deportable at that point. He didn't actually become deportable because of the conviction until the waiver was denied. So to have a straight 2-year rule would fly in the face of prejudice. He was not prejudiced until that point when the waiver was denied, sir.
Do we even know that if misdemeanor renders a defendant deportable?
It does, Judge, for 2 reasons, as I've stated in my brief. 2 crimes of moral turpitude, not of a single scheme under immigration law, can render a alien inadmissible and ultimately deportable. The state's citations to matter of B and matter of E, which were cases which were decided in New York and Massachusetts, which has nothing to do with the law here in South Florida, say they're not crimes of moral turpitude. We say they are under the law. Or alternatively,
wasn't that I guess the whole purpose of requiring initiation of deportation proceedings is so that the state courts don't have to get involved in all these matters of immigration law, which they don't understand. It's up to the federal government to decide whether something renders someone deportable or not, and it's at that point that they can show prejudice.
Well,
anything other than that is speculation.
I would say not, sir. I say it's incumbent upon counsel to present an expert witness, a former immigration judge or a former expert in immigration law who will opine as to what, in fact, the effects of this would be, and a circuit court judge would be in a fine position to make a determination.
An expert cannot testify about whether somebody is actually, or whether the government has actually initiated deportation proceedings, if that's the point.
Well, I think in pointing out Justice Ansted's concurring opinion in Pert, although he didn't define threat of deportation, he talked about the legal possibility of deportation, with the fourth DCA talked about in the Marriott decision. Pert approved Marriott. And it's got to be the legal possibility of deportation, which is the test, because, to use an illustration, it's common knowledge in South Florida that Cuban nationals are not deported back to the island of Cuba, even though deportation proceedings are commenced, and even though they are technically entered in order of deportation in such cases. So you have a situation where if you use the state's test, it just doesn't make sense. Until the government of Cuba starts accepting...
You're talking about a subset of immigrants. We have to write the law for the entire state.
No, I understand that, sir. But what I'm saying is, until such time as the government of Cuba changes its policy, you would have had a situation where someone would have been deported, the notice to appear would have been filed, they would have had it enter an order of deportation, and yet they would still be here. So the bright line test that the state is suggesting...
I guess you're proving too much, though, because that argument says even the initiation of deportation proceedings is not enough. Well, it's an argument to start it even later, not before.
I'm just using that as an argument, Judge, to show you that a bright line test doesn't necessarily work.
The bright line test is, and Justice Anstad in his concurrence, the dissent had said it would be actual deportation, and he said, as opposed to the initiation of deportation proceedings. So although the majority didn't talk about the threat being the initiation of deportation proceedings, that's an earlier date than the actual deportation. And let me ask you, it sounds like you have immigration law knowledge.
Somewhat. I rely on information I've received. Well,
the question I have is, and maybe it doesn't appear in this record, but is there anything that we can refer to that from the point of the initiation of deportation proceedings, what is the usual time period until an order of deportation?
Chief Justice Pariente, because Justice Lewis addressed it, and it's very important to understand. From what I understand, recently speaking to a former United States immigration judge who I asked that very question about, sometimes immigration judges don't grant you continuances. So what happens as a practical matter is if you go in and they begin deportation proceedings, you don't have time to come back to the state court to vacate. So if you use this initiation test, then you won't be able to vacate, and the whole rule under 3850 in these kinds of cases will be frustrated.
But won't that require the trial judge in any given case to have to evaluate the legal effect of whatever it is that the defendant receives to know whether this is something, like you're saying here, it will come out that the waiver when the waiver was denied, he was now deportable.
Yes, ma'am.
But that will have to be established, and that will require a trial judge in every case to make a different legal determination about what the effect is of a given status.
Respectfully, I don't think so, Judge. I think you would present the immigration lawyer who represented the person, who told him when he explained the effect of the waiver.
What prompted your client to file a request for a waiver?
I'm sorry, ma'am?
What prompted your client to file the request for the waiver?
He had become inadmissible because of the conviction for assault and battery. And due to that, his lawyer...
So he knew that at a long time before he actually filed the waiver request?
No, because what happens is until such time as the waiver is denied, he didn't become deportable. He's inadmissible, meaning that he is out of status in the United States.
So at the time that did
But
he
he
have a
has
visa
available-
at some point?
I'm sorry, ma'am.
Did he have a visa at some point?
Yes, but he overstayed.
And so at the point he overstayed his visa, don't you become deportable at that point?
No, because he has a waiver available to him from a close family relative, his wife. But when he was convicted, the basis for the denial of his waiver would have been the criminal
But
conviction.
in a general case, wouldn't a person become deportable once their visa has expired?
Not deportable, inadmissible, Your Honor. He'd be out of status.
Inadmissible or deportable, you are no longer legally in the United States, correct?
That's correct, but you have
And
an
so
available...
why isn't that? Why wouldn't that be a good point at which any defendant would have to then raise the claim that he was not properly informed of the immigration consequences of his plea?
Because he became deportable only because of his criminal conviction. Despite that, he would have had the waiver available to him to overcome that.
Well, we're talking about, you're talking about your client in particular.
Yes, ma'am.
But I'm talking about aliens in general.
In my brief, I make mention of certain individuals who are never in a situation where they can apply for a waiver. For instance, drug defendants who are convicted of drug convictions, domestic violence defendants who are convicted of those kinds of convictions have no waiver.
Even in those cases, when you can't get a waiver, you still have to wait until the INS decided to institute deportation proceedings. So a defendant can really just sit around and wait, and all the evidence disappears and all the witnesses disappear, and then file a claim that under 3.850 that he was not properly informed of the immigration consequences.
Well, I'm not sure that would be the case. If he didn't get his warning, the whole point goes to the voluntariness of the plea. So he would not know until he consulted with a lawyer, until he got those warnings and someone investigated that was the case, together with resultant prejudice, whether he would be subject to deportation. And I think that's why the court in Perth v. State said you have 2 years from the time you learn about that. This is a different species of case. It's completely different.
Justice Quintero has a question, then
Yes,
Justice
sir.
Lewis.
Getting back to your answer to the Chief Justice about the initiation of proceedings, it seems to me that you were talking about sometimes the immigration judge won't grant a continuance.
Yes, sir.
Every alien, as far as I understand, has an absolute right to an appeal to the Board of Immigration Appeals, correct?
That's correct.
And from there, an appeal can go to the United States Circuit Court of Appeals in that particular circuit.
That's correct.
And that whole process could take, at a minimum, several months, usually more than a year. Isn't that correct?
That's correct. But still, the issue is the plea voluntary and can it be set aside?
I understand. I'm just talking about some of the justices are concerned that if we make the bright line initiation of proceedings, that there isn't enough time then to seek a withdrawal of the plea. And I believe that there's at least over a year that happens between the time of initiation of proceedings and the time when a defendant or an alien can exhaust his administrative remedies.
But the more important question, I think, Justice Quintero, is the test of the legal possibility of deportation superseding the bright line test.
I understand that's your position.
Should we have, or is there a necessity for, and what's your response to the issue with aliens enter under different status? Some may come under a visa, some may just enter.
Yes, sir.
Should there be a distinction for those who have just entered that they should know? Because you look at PERT, it talks in terms of knew or should have known. I mean, they're subject to deportation, I would assume, at any point, even without regard to the plea. So is there a legal reason for a distinction between groups within that group? I mean, is that an issue?
I think there may be many legal distinctions between groups because the immigration law is varied, but I think that's why you have an immigration lawyer who's going to explain to an immigration defendant when he becomes deportable
Well,
as a result of an
the answer to
uncounseled
that
plea.
question, though, is if somebody is illegally in this country, then they're going to be deportable regardless of whether they had been convicted of a misdemeanor or not. So they're not going to be able to prove prejudice because because they'd be deportable otherwise. That would be a
Not necessarily. They may be a legal resident who's absolutely here legally. But in the case of a drug conviction, a legal resident...
No, but I'm saying in the case of a defendant who is in this country illegally...
Yes.
Then they are probably not going to be able to prove a prejudice prong of the under PERT, because the reason for them being subject to deportation is because they were never in this country legally, not because of a subsequent conviction. And
well,
that's
Judge,
just going to be a question of proof. Do you agree with that?
I understand what you're saying, and I take exception to it because they would still have, as Mr. Green did, he was here as an overstay, but he had a waiver available to him. Once the waiver was denied, he became deportable.
I'm talking about someone that doesn't come into this country legally to begin with.
Different Mexican crossing the border, for
well,
instance.
There's millions of people in that status.
Of course. I think that the issue is the 2-year rules. It's very important to understand from when a person learns or should learn of the consequences of deportation. That's why the court can't have this just 2-year rule from the time of a conviction.
It seems to me that this whole thing is just, and I recognize that I dissented on this very basis, but how in the world, practically speaking, are you going to objectively be able to come up with a point in time when someone should have known that they were subject to deportation? It seems to me that is just fraught with inequitable administration.
Well, for instance, in this case, when the waiver was denied and the client was informed by the immigration lawyer that that was the effect of the denial.
Well, then he knew it. He should have known it.
Most of these people are not educated people, Justice Wells.
Well, when you come into any country, go to any country, you realize as a basic condition of entry into the country, you got to abide by the laws and rules of the nation, right?
Of course, Justice.
And if you violate it, then anyone with any common sense know that if you have a special permission to be in a country, if you violate that country's law, that it might subject you to being, at the time you entered this plea in this case, wouldn't any person with any common sense understand that they violated the law in the United States and were here with some permission, that might impact their ability to remain?
In that limited case, but most of the time these cases may involve legal residents who are absolutely here and waiting to become naturalized. A criminal conviction of a crime involving moral turpitude, like a drug conviction or a domestic violence misdemeanor, would subject a legal resident to deportation. And they wouldn't know, Judge, unless they got the...
When he entered this plea, your client entered this plea way back when.
Yes, sir.
Was he subject to be deported because of that plea at that time?
Yes. There are two bases for it. If he was involving himself with a conviction of moral turpitude, which is the assault and battery conviction, which is under immigration law determined to be a crime not of a single scheme of conduct. Under that standard, yes. Or, alternatively, when his waiver was denied down the line, he also became deportable. So the answer to the question is yes, sir. And I think if you look at my footnote in my brief, it speaks to that. And I should also...
Did he have a right to the waiver, or is the waiver a discretionary?
Waiver is discretionary, but as I point out, under HCFR 212.7d, you must show as an alien extreme and unusual hardship to have the waiver granted. So the fact that even though it's discretionary, it really doesn't come into play. He's really not going to get that waiver granted because of the conviction in this case.
Let me ask you, how does the counsel's conversations with your client also enter into the calculus in determining whether the client knew? There may be cases where the judge does not advise the defendant of deportability, but the counsel does. And
Correct.
Therefore, the client did know about it and there was no prejudice. Does the state now have to present the defense counsel a trial to show that the defendant actually did know about the possibility of deportability?
I think most respectfully, Justice Cantor, the burden is on the defendant to produce because the rule in PERT is it's 2 years from the time you learned or should have learned of the threat of deportation.
So part of the defendant's onus at the evidence you're hearing is to present defense counsel
Yes.
to say that defendant did not advise him of the
Well,
possibility.
the defendant can set it, but with credibility findings being what they are, prudent defense counsel would want to present a lawyer to present such testimony.
Oh, but the defendant can say it himself.
But of course,
If he chooses.
if he chooses.
Yeah.
But of course, prudent defense counsel would want to buttress that testimony in an appropriate way. I also wanted to speak.
You're out of your time.
Yes,
Did you want to make one concluding comment? Because I'm going to give
Yes,
Mr.
with regard
Carney-
to waiver, we still think there's a waiver with regard to the state's failure to raise these issues below. We think that if the petition was insufficient, it can be dismissed without prejudice. And as to the jurisdictional issue, we again would ask the court to allow us to amend or to extend the time to file. We did file the notice of appeal based on a mistaken interpretation by the trial court. Thank you very much.